Tonight, the Supreme Court taking a stab at Obamacare. Justices have sided with family-owned craft store Hobby Lobby and its push to opt out of providing certain contraceptive health coverage for its employees. Where do most Americans stand on this ruling? And the so-called Central Park Five has settled their lawsuit against the city of New York, receiving $41 million, and tonight they are speaking out. Raymond Santana talks to RFL. Santana was only 14 years old when he was arrested and wrongfully convicted for the rape of the Central Park jobber. Well, tonight, the new Court of Appeals in New York says town officials can approve zoning laws to ban fracking, and the court says its decision has nothing to do with the environment. We're going to get into all that and much more in the next 60 minutes, so thank you very much for joining us and a good evening. I'm Richard French. Well, tonight we will begin with that ruling handed down by the nation's highest court. In a 5-4 decision, and that split seems to be getting more and more common, the Supreme Court sided with family-owned craft store Hobby Lobby. Court ruled that some private employers can opt out of contraceptive health care coverage for their employees. Hobby Lobby has over 500 stores with more than 15,000 employees, and it offers health coverage for 16 types of birth control. However, the owners, who are Southern Baptist, are against offering health coverage for 4 types of contraceptives, including versions of the morning after pill and IUDs, which they believe to be a form of abortion. Now, Justice Samuel Alito, who wrote for the majority decision, said, "We doubt that the Congress that enacted the Religious Freedom Restoration Act, or for that matter, ACA, would have believed it a tolerable result to put family-run businesses to the choice of violating their sincerely held religious beliefs or making all of their employees lose their existing health care plans." The White House says that women's health will be jeopardized as a result of the decision.
President Obama believes that women should make personal health care decisions for themselves rather than their bosses deciding for them.
The Supreme Court recognized that American families do not lose their fundamental rights when they open a family business.
Well, the public seems to disagree with the High Court on this. A new Reuters poll shows that most Americans do not support the decision of the Supreme Court, 53% disagreeing with giving private employers the right to choose contraceptive coverage. 35% agree with the decision and 12% on the fence. Gallup poll also shows Americans' confidence in the Supreme Court is at the lowest level that we've seen since 1973. All right, this is also our question this evening. Should a company's religious values dictate the health care coverage it provides to its employees? And so you see how you can get involved both via Facebook and Twitter, so please make your opinion heard. Well, let's get the opinions of our table. Let's bring in our panel. Jeannie Zaino, familiar face, professor of political science at Iona College and a professor of campaign management at NYU. Dominic Carter, political journalist and author. We're going to hear his interview with one of the Central Park Five coming up in just a little bit. Richard Willstatter, a partner at Green and Willstatter in White Plains and past president of the New York State Association for Criminal Defense Attorneys, and Mark Furnish, professor of Brooklyn Law, and he has argued before the U.S. Supreme Court. And Andrew Whitman hasn't argued before the Supreme Court, but argues about just about everything else. He's our senior political correspondent.
Before this court.
Yes,
this
absolutely.
is a much tougher bench.
Well, Mark, I'll start with you. You know, it's always dangerous to predict Supreme Court rulings. I always like that when people do. But most people that I heard didn't think the decision would have came down the way it did today. Were you a little surprised that Hobby Lobby got the benefit of the doubt?
No, actually, because it came out exactly the way that I thought it would when we discussed it on this program before cert was granted. And I always felt that the problem with this aspect of Obamacare was that it's not narrowly tailored enough, and that's exactly the fulcrum of the court's opinion today. And what's really interesting about this opinion and about the poll that you just ran, if 53% of the public disagrees with this ruling, there's a great way they can overturn it, because this case wasn't decided on First Amendment grounds. It was decided on the basis of a statute passed by Congress that affords religious people greater protection than the First Amendment itself. So what's the way to overturn the decision? Elect a different Congress that pairs back the Religious Freedom and Restoration Act, or the mouthful RLUIPA, which is the Religious Land Use Institutionalized Persons Act or something.
But here's the part, Mark, that I was confused about, which was there were exceptions carved out, which was if you were a religious institution, if you were a church or even an affiliated hospital with a church, you got exempt from basically having to abide by Obamacare. So why should Hobby Lobby, or for that matter, any other private employer decide, well, you know what, my religious objection, in this particular case, it has to do with reproductive freedom, but it could be for other things. I get to dictate for my employees what they can and can't have.
Well, they didn't say that you get to dictate. First of all, the issue is the way the statute defines person. And person, it employs the traditional legal fiction that a person includes, for legal purposes, a corporation, as well as a natural person. So this is not Citizens United Revisited, it's purely a question of statutory interpretation. And the court is not saying broadly that anybody can opt out on any basis they want. They said in this case, there's a less restrictive means of accomplishing the Healthcare Reform Act's goals than forcing these people to provide funding for contraceptions that they disagree with.
Richard, do you think that the ruling is narrow in its application, or do you think that this thing could be more far-ranging than just they don't want to provide IUDs and morning after pill?
Well, I think it actually was an attempt by the court to reach out to assuage religious Christians and make those people feel that they were somehow protected by this Religious Freedom Act, when in fact what they said the remedy could be, which applies to these religious institutions, is not in fact the law now. And it actually means that someone is going to have to pay for that health care for those women that is currently covered by the Affordable Care Act. So somebody's going to have to, as Justice Kagan said, pick up the tab. And just because the Supreme Court repeated over and over again about how, well, it's going to be negligible, the whole point was that Hobby Lobby didn't want to pay for it. So somebody else is going to have to pay for that. And it's the, it's the women's reproductive freedom and health which is at issue here, and which I think is just as important as the religious views of the Hobby Lobby or whoever is the employer.
You know, Jeannie, maybe it was coincidental, maybe it's because there are three progressives, but the three female justices in the Supreme Court disagree with the majority on it today. And a lot of people thought that this was a direct shot. And it wasn't just that it's coincidentally about reproductive rights, but that was a shot against a woman's right, and this should be a decision that she should make with her doctor, and no employer should be able to step in the middle of it.
Yeah, no, it is interesting. All three of the women, were in the minority on this one, or in the dissent on this one. And, I think one of the big questions that's raised, so if I'm a corporation and I oppose blood transfusions, for instance, and I'm a closely held corporation, do I then get the right to withhold that funding? To me, this does speak to an issue of women's reproductive health, which, if you look at what Alito said, seems to be in a different class than other medical and health procedures. And I agree with you. I mean, I think one of the problems here is that the Obama administration opened this up when they opened up the exemptions for religious institutions, giving the court a perfect shot to say, hey, you could narrowly tailor this. It's not going to be a lot of money. Whether that's true or not, the government can pick up the tab. There's other ways to do this, and the First Amendment and the right to religion and right to your religious exercise is so important, we're not going to step on that. They opened that door up, but I think there's a big question about what else is going to be allowed. And when you describe, I saw Andrew's face when you're talking about corporations as people. It's just so hard to wrap your head around. Corporations also get other protections that people don't get. Do we now start to get those?
Well, that's right. The downside, or one of the downsides of the decision, is that they get the benefits of the corporate form, but don't pay the penalties that come with the corporate form, so they're getting a double dip. But this isn't like Merrill Lynch or Alcoa or something like that. This is the mom and pop corporation, and what the court said, and you can take it at face value or not, the transfusion question, the vaccination question, that's going to depend on whether there's a less restrictive accommodation available. And you're absolutely right. The Obama administration has sort of been hoisted on its own petard by trying to carve out the official religious organizations, and the court said...
though, it's funny because, Andrew, usually you do the holdings of the court, and you'll do the majority and dissenting opinion for the audience. It just seems more and more often it's 5-4, and I do think that it is not just something to skirt over, that it's been more than 40 years since the public has held the opinion that they have at least a low level of a competence opinion of the High Court, and that's not healthy. You can disagree with the justices, but at the end of the day, they should, at least in the eyes of the public, be applying the law. I don't think it's healthy, and maybe you go back to Bush v. Gore as really being the impetus of it, but it's not a good thing when people start to think of it as just another political wing.
Well, the Supreme Court by design is supposed to move slower in its opinions and social mores than the country does. I think that's one of the geniuses of the design of the Supreme Court. But we're getting to a point now where it seems like the social opinions of the court are getting further and further away from the majority views of the United States and of people in the U.S. We saw the polls on that, specifically to this case, and generally the views of the Supreme Court. There's just one other thing I wanted. You had mentioned that it was, not Merrill Lynch or these big companies, but I'm looking at an article right now that says about 90% of the companies in the U.S. are closely held companies. They're small businesses. This network is one of them. So we are actually talking about a lot of people and a lot of businesses. This is not just Hobby Lobby or some exceptional companies here or there. There's a lot of companies affecting a lot of people. And the real question is what happens now? If Hobby Lobby says that, being gay is not, that's a class of people, so that's different, but there might be some objections there. There are a whole bunch of objections that could pop up.
There are a lot of challenges one could mount to this law, and one was successfully mounted when it first came into being, given that it was struck down on 14th Amendment grounds. They rejiggered the law so that it was passed under Congress's commerce and spending powers. It has an insanely broad definition of the exercise of religion. So there are many, many grounds on which you could attack this statute. And in terms of the court's credibility, they didn't go incrementally in the Warren Court. The Warren Court dragged the rest of the nation kicking and screaming into the civil rights era, and the court caught a lot of flack then. What happens is when the court reaches out, as it has done for the past several terms, to decide hot-button political issues, it just looks like another partisan branch of government, and it's the public confidence in it as an institution is undermined.
And what I'm saying is anecdotal, but it seems that when the court will go in a direction that you see in the arc of time and history, eventually the country will get there, that's one thing. But it seems that it's making a decision that's going the opposite direction of the trajectory of where the public sentiment is going.
Well,
I mean, more than 90% of Americans, use birth control. Right. American women use birth control. So the premise of that they want to restrict certain usage of it certainly isn't fitting into the mainstream of where the public is right now. And that shouldn't be the only judgment. I'm not saying that's what the Supreme Court, it just didn't feel right.
But think about same-sex marriage, though. They're out in front of that debate.
But if the Warren Court was working for civil rights,
yeah.
This court is working for the Chamber of Commerce, or it seems to be advancing the Chamber of Commerce.
I got to get to a break.
But this is what you get when you have an unelected institution. You can agree with them or disagree with them, and you're sort of stuck with them because of life tenure. That's it.
And with that, thank you, Mark. Okay, a case, this next one we're going to get into that rocked the country. 5 young teens. Think back, you remember the images here. You're going to see them in a second. Coerced into confessing to a crime. It turns out they didn't commit. Now the Central Park 5, as they became known as, they've reached a settlement with the city of New York. Raymond Santana, who was convicted in the case, speaks out to Dominic. We're going to have their conversation after the break.